You're listening to Navid Moosa of the Mindset Movement. All right, thanks for joining us here at mindhairtohomeoptions.com. My name is Navid Moosa. Thanks for clicking, giving us an opportunity to talk to you in regards to your situation. If you're contacting us after you've lost a loved one, please accept our condolences. We understand this is a difficult time. Here at Inherit Home Options, what we try to do is try to take all the information that you have coming to you at 100 miles an hour and try to slow it down. And we do understand that it can be overwhelming, especially if it was if the loss of your loved one is something that happened unexpectedly. Even if it's expected, it's still hard to deal with no matter how you paint it. There isn't a phrase, a word, a text message, or a phone call that can ease that pain, unfortunately. But it's just something that does have to be dealt with. What we try to do here at inherithomeoptions.com is just have a conversation. No obligation, no commitment. We're just going to talk. And what we want to do is provide the best possible value we can to you to get you some kind of direction. Having said all that, being this been such a long time, we try to partner up with people who can give value in return and not just want to get into your pockets. We want people who are going to be there for you. So we have Kevin Conrad here, who's from Lamb. I'm going to butcher this name. You just told me twice. I saw a pie. I said, man, Lamb Mackerlane?
Correct.
Thank you very much. It's Kevin Conrad from Lamb Mackerlane Attorneys at Law. They specialize in probates as well as other facets of law. They have offices in Westchester, PA, Newtown Square, and Philadelphia. So Kevin, if you could just please introduce yourself to the persons watching this video.
Sure. First, Navid, I'd just like to say that as required by our firm, this does not constitute official legal advice. And if you have a specific legal question, you should notify or contact an attorney of your choosing. So by way of background, Navid, I've been practicing law for approximately 17 years now. I started at a firm in Montgomery County where I was for about 10 years, and I've been at Lamb Mackerlane based out of the Westchester office for the past 7 years. My practice includes estate planning and estate administration, corporate work, real estate, and some litigation as well.
Great, thank you very much. So if someone comes to you and the probate, and again, we've been doing this for a while, just as long as you have. And some of the questions we see, or the number one question is, what's the difference between estate planning and administration? Could you kind of sum that up for us real quick?
Sure. So estate planning is what is done on the front end before somebody passes away. And estate administration is what takes place after the person passes away. So the better that your estate planning is on the front end, the easier it'll make it for the person who is administrating your estate on the back end, which is the estate administration. So estate planning is important, obviously, to prepare for the person who will become your executor or your personal representative to administer your estate after you pass.
Okay, great. Thank you very much. And so what would you, actually, I will just get into the questions. Again, we deal with enough of these where we have people asking us questions, and I have a list here kind of prepared. Don't want to catch you off guard here, but we've dealt with some deals, you and I in general. So I think we have a comfort level here. So I'm going to get right into it right off the back. And here we go. The first one I have is, what is the difference between probate and non-probate assets?
Sure. So probate assets are assets that are held in an individual's sole name. And those are the assets that need to pass through the Register of Wills. So non-probate assets would be assets that are titled either in joint names or that have a designated beneficiary. So some examples of some non-probate assets would be a joint checking or savings account, an IRA with a beneficiary designation, life insurance policy with a beneficiary designation, real estate that is held in joint names. Those would all be considered non-probate assets. And those non-probate assets do not have to pass through the Register of Wills. They pass by beneficiary designation. What that means is if you have an estate that only includes non-probate assets, that in other words has no assets that are held in the decedent's sole name, you don't have to go through the probate process at the Register of Wills. And those assets can be passed, those non-probate assets can be passed directly by beneficiary designation or by the way that the property is titled.
Okay, great. Thank you. The second question is, must a will always be probated?
No, and that follows up on the previous answer that I just gave. If there's a will out there, but there are not probate assets, there's no need to bring the will to the register of wills and probate the estate. Everything that would pass by a non-probate asset typically involves the presentation of a death certificate by the beneficiary to whether it's the life insurance company, uh, the bank, a title company, whatever it might be. You don't have to probate a will if there are no probate assets. And as a word of caution, some people don't realize that, and they'll go to the register of wills, probate the estate, even though there are only non-probate assets. And once you start that process of probating an estate, even if there are non-probate, if it's only non-probate assets, you still need to follow through with all the processes and procedures that are involved with the register of wills. So it becomes a somewhat time-consuming and can become somewhat costly, relatively costly, to go through the probate process when it wasn't even necessary.
Now, does that vary county by county or state by state, or is this just for PA law, or how does that work?
Well, I only deal with PA and Jersey law, and that's certainly the case in PA and Jersey. But to my knowledge, that's the way it is across the country. It's
Okay.
non-probate asset. There's no need to go through the road.
Okay.
That being said, non-probate assets are still taxable for Pennsylvania inheritance tax purposes. So
That was my next question. So I'm glad you already clearly answered that, because that's a huge thing. It's, they still tax you even after you passed on, unfortunately, but it's here in PA. So third question: what happens to a decedent's assets if they die without a will?
if a person dies without a will, like I said earlier, estate planning on the front end makes it easier on the back end for the estate administration. So if somebody doesn't have a valid will in place, um, it doesn't mean that the estate assets go to the Commonwealth of Pennsylvania, which is another common misconception. People think if they don't have a will and they die, all of their assets will then go to the Commonwealth. That is inaccurate in the sense that there is an intestacy estate statute in Pennsylvania, which determines the sort of priority or pecking order of who receives what from your estate. And that priority list obviously favors the spouse of the decedent and the children of the decedent. There's a specific statute that addresses. So if you die without a will, you'll still need a personal representative appointed if your estate involves probate assets. And once again, there's an order of priority of who can be appointed the personal representative of your estate if you die without a will.
Okay. So actually, that brings up the other question I have here is, what estate assets are subject to Pennsylvania's inheritance taxes?
Unfortunately, mostly everything is the answer. It's all tangible and intangible assets of the decedent, real estate, bank accounts, IRAs, 401ks. For the most part, everything that is held in your name or even in the name of a trust where you had owned the assets at some point, whether it's a revocable trust or a irrevocable trust, those assets can be subject to Pennsylvania inheritance tax. The one exception to that is life insurance. Life insurance is not taxable for Pennsylvania inheritance tax purposes. And the other thing is that if you have joint assets, those are not taxable at 100% of the value of the asset. So in other words, if you have a joint bank account with your wife or your child, well, I shouldn't say your wife, because all transfers, spousal transfers, are 0% transfer tax rate or inheritance tax.
Inherited, yeah.
But for children, the inheritance tax rate, lineal descendants, children, grandchildren, that tax rate is 4.5%. But if you have a bank account in the name of you and your child, that joint bank account is only taxable at a rate of 50%. Now, the one caveat to that is that bank account has to have been established in excess of 1 year of the date of your passing. And I'm dealing with an estate right now that has that issue where I wasn't involved on the front end with the estate planning, and there were some last minute, I wouldn't say deathbed transfers, but transfers that were made in the past few months. in an attempt to try to avoid inheritance taxes. But unfortunately, they will be those assets will be subject to inheritance taxes because the transfer were made within 1 year of the date of death. So all, and going back to the estate planning part of it, it's important to do the estate planning early on the front end so you can avoid some of these issues on the back end with the estate administration.
So that estate planning is really the foundation that people really need to be made aware of, that, doesn't matter how old or young you think you are, or whatever, how healthy you are, that estate planning is key and it's crucial, right? It's probably a uncomfortable discussion for people to have about death. I understand that, but it is a part of life. But that just, I mean, I just want to ask you several questions and you go back to that estate planning almost every single time. So, but thanks for drilling that home because it's a necessity. So the next question I got, I'm a little bit hesitant to ask it because it can get misconstrued, but are there any estate planning techniques that can be utilized to avoid Pennsylvania inheritance taxes?
Right, right. And we're not trying to commit tax fraud here.
Yeah, exactly.
This is on the estate planning side as well. So the two most commonly used ways to avoid inheritance taxes through the estate planning process is one, through making joint accounts, whether it's bank accounts. You have to be a little bit careful about real estate. I think we'll get into that a little bit later, but adding people to your bank accounts as a joint account holder can avoid at least 50 previously. The other way, which is the easiest way, but not always the way that people that are doing estate planning want to pursue, is to gift assets from your estate while you're still alive. They're called inter vivos transfers. You can gift your children, or you can gift anybody certain amount every year. Right now, it's $15,000 per year per donee that you can transfer. I said it doesn't necessarily even have to be a loved one or a relative, up to $15,000 a year. If you want to transfer any amount above $15,000, you're entitled to do that, and there are no tax implications at that point. But what you need to do is you need to file a federal gift tax return to show that you made that gift and the amount of the gift. And gift tax returns are a little bit more complex, and I would recommend that anybody seek counsel or a CPA or an accountant to handle that gift tax. So joint accounts and gifting are typically the two ways that, while they're doing the estate planning, in addition to some complex trusts, which are a little bit beyond the scope of this conversation, but there certainly are ways to minimize or to.
Okay. Yeah, and as a reminder, this conversation is we're not going to cover every last nook and cranny because it'll go on forever and ever. We just want to get some of the basics in and stuff like that. And at the end of this video, for those who are watching, Kevin will have his contact information up there and stuff like that. So if you guys wanted to set up one-on-one with him, you could definitely do that to drill down on anything that he maybe touched on and we couldn't get a chance to elaborate on. The other question of the follow-up is, should I transfer title to my house into a revocable trust?
That's a good question, and there are certain situations where you might want to consider that. There are other states where the probate process is much lengthier than Pennsylvania and more costly than Pennsylvania. The Pennsylvania probate process, relatively speaking, is not a super lengthy process and necessarily a super costly process, where in some other states, everything has to go through the courts. In Pennsylvania, the personal representatives, executors are pretty much allowed to manage the estate without court intervention. So to your question, some people will put real estate into a revocable trust to avoid probate. And it certainly does that. It serves the purpose of that. So in other words, the revocable trust is set up after somebody passes, the property passes in accordance with the terms of that revocable. And you can also control the disposition and the use of the property through a revocable trust that's set up during your lifetime. When you pass, that revocable trust actually becomes irrevocable, so that the terms can't be changed by the successor trustee. So some important points about putting the property into a revocable trust is one, make sure that you have lender approval for that. In order to change, as you know, in order to change title or change names on a deed, if there's a mortgage on the property, according to your loan documents, it's going to be required that you get lender approval to do that. So you can't just draft a trust document, have somebody draft a deed for you, file that deed, switching the ownership of the property from your individual name or you and your spouse's names into the name of the trust. You have to go through the mortgage company to make sure that they approve that, and that can involve some refinancing if there's going to be on the title. When the property is owned outright and there's no mortgage or financing on the property, it's much easier to put it into a revocable trust. The second point on that is if you do switch it into a revocable trust, make sure that you notify your homeowner's insurance company to make sure that the revocable trust is now listed as an insured on that insurance.
Okay. Should I transfer title to my house to my children in order to avoid Pennsylvania inheritance taxes?
Another very good question. Another not straightforward answer, as is
Yeah.
typical in some of this stuff. So there are reasons why you'd want to transfer title of your real estate to your children while you're living. There are some Medicaid reasons why you might want to do that. There's a 5-year look back period for Medicaid purposes, so you might want to get assets out of your estate before you have to apply for Medicaid. There's obviously the issue that you just mentioned about trying to avoid Pennsylvania inheritance. And if you live beyond 1 year from the date of that transfer of the house, that will certainly avoid Pennsylvania inheritance taxes. The hiccup in all of that process is that when you transfer the house to your children, there are certain situations where you can avoid this issue. But the major issue when this occurs is that you lose this, your children, your beneficiaries lose the step up in basis on that property. So in other words, if you bought the house 30 years ago and it was worth $100,000, or you bought it for $100,000, and then you transfer it 30 years later for $1 million, your children, that $900,000 increase in value will be subject to capital gains taxes when your children sell that property. So most often, it doesn't necessarily make sense if it's purely for a Pennsylvania inheritance tax purpose sake to avoid a 4.5% Pennsylvania inheritance tax to have your children end up paying a large capital gains tax when they go to sell that property. So certainly, I would seek legal counsel if anybody ever considers transferring real estate to their children while they're alive. There are some potential workarounds, some grantor trusts and some life estates that can be done. Also, if the children continue to live in the house, there are some ways to avoid that loss and step up in basis, but certainly seek legal.
If I am named as an executor on a will, do I have to serve as the executor, or can those duties go to somebody else?
Sure. There's absolutely no requirement that anybody serve as an executor or representative listed in the will. And oftentimes, somebody might think that there's a better person to do that. Sometimes people might not even know that they were named an executor in a will. An attorney might retain the will. Family member might retain the will, and the person might not even know that they were named until the person even passes. So in that situation, you don't have to serve. You can file what's called a renunciation at the Register of Wills. It's a one-page document that has to be notarized, saying that you no longer want to serve, or you never intended to serve as the executor of the estate.
And then at that point in time, you could designate somebody else to be that executor.
Correct. So the way it would typically work is if there's a successor executor listed in the will, then that person would become the executor. There's an alternate. Otherwise, like I said earlier, there's a statute that would apply as to who has the right to serve as the personal representative. So it would go to that statute to say, okay, priority wise, who would be entitled as the executor. The register of wills wouldn't necessarily take the person who is renouncing their executorship, their recommendation necessarily. Uh, Obviously, if there was an alternate listed in the will, then that would override.
Okay. Um, should I serve as the executor of an estate that is insolvent?
Another tough question. You have some tough questions here today. So I've seen that quite a bit over the years, where the estate is insolvent and somebody still chooses to be the executor of the estate. And in those situations, it's typically a feeling of a moral obligation on behalf of the executor that they have to the decedent, that they want to make sure that their affairs are um, wrapped up properly, that the estate is administered to the best of their abilities, even though they realize there are going to be some headaches along the way, and there are going to be times when they look back and possibly say, why did I ever get involved in this, knowing that the estate is insolvent. And sometimes at the beginning of the estate, you might not realize the estate's insolvent.
Could you actually define or give an example of what insolvent is, or how it would be defined?
Sure. So insolvent would mean that the estate has more liabilities than assets. So in other words, there will be no assets available for distribution to the beneficiaries after the estate is probated. Now, we're only talking about probate assets when it comes to an insolvent estate. There could be non-probate assets that don't pass through the will or pass through probate that can't be touched by creditors. But say, for instance, there's a house that is worth $200,000, but it has a $250,000 mortgage on it, and it's passing through probate. That house, there's going to be no proceeds available for distribution to the beneficiaries. You still have to go through the probate process if you want to try to sell that house.
Yeah, and that on a side note, for those who are watching, Kevin and I actually, as of the recording of this video, we're working on one that's in that case, unfortunately, but it does happen. If real estate is part of it, and man, this is another insolvent question. If real estate is part of an insolvent estate, what options do I have?
All right, and as you know, with the case we're working on right now, the main option is you can try to sell yourself, which is very difficult. What typically happens is the personal representative seeks a short sale of the property.
Okay.
So what that short sale means is that, once again, the property is quote unquote underwater, meaning that there is a mortgage on the property that is greater than the value of the property. And a short sale would be a situation where the bank, the lender, would agree to accept a purchase price for below what the either fair market value is or what the amount of the mortgage is. So in those situations, there are companies out there, I can certainly say the one we're working with because I've worked with them several times, but there are short sale companies out there that do an excellent job with negotiating on behalf of a personal representative. They have the contacts at the lenders, at the banks, to get the short sale approval process done. Now, it doesn't always work out. There's no guarantees, but it certainly, the company that we're working with now has smoothed the process for me on several estates where I never thought the property would be able to get sold. And they were able to negotiate on behalf of the personal representative to get approval to sell the house, even though it wasn't worth what the mortgage was on the property. So that would be the first option. The second option is a deed in lieu, which is basically you turn over the property, you transfer the deed back to the lender and walk away from the property. Typically, lenders, they have internal, and depending upon what bank it is or what lender it is, every lender and bank might have a different approval process for this. What I've seen in the past is the lenders will always want you to try to do a short sale first, or they'll accept a deed in lieu. And a deed in lieu is a deed in lieu of foreclosure. So it would mean that you are signing that deed over to the bank, and they are agreeing not to foreclose on the property. The third option, which is really the bank's option, is to foreclose on the property, which can be, a somewhat stressful process for the personal representative, even though there's no personal liability to the personal representative receiving foreclosure notices on a property that you are administering an estate on. It gets a little stressful for the personal representative. So to the extent you can, a short sale would be the best option. A deed in lieu would be the second option. If all else fails, I mean, the property would be foreclosed.
Okay. So it's kind of ironic because even those are the same option that you're given, even when you're still with us. 'Cause I do a lot of foreclosures in general, and you get that letter and it says if you don't pay, we're going to foreclose on it, but we can do a short sale or you can just sign it over to us. And like you said, they don't really want the asset back. They want it sold, they just rather, so a short sale is probably the best way to go. So I absolutely understand and hear where you're coming from on that one. And for those who are watching this, we do short sales here. So please don't hesitate thinking, oh, we're upside down or the condition of the property. You'll be surprised what between Kevin, another third party company that we deal with, and what my team here at Inherit Home Options can kind of accomplish. As long as communication is there, we can really help you guys out. All right, two more for you, then you're off the hot seat. Am I entitled to compensation for serving as an executor?
You are actually, and as you should be. I mean, being an executor is, as we talked about, not an easy role. It's not without stress. It can be very time consuming. So there is a statute that allows for reasonable, what quote unquote is reasonable and just compensation payable to the executor of an estate. And what reasonable and just is certainly a vague phrase. And if you have an attorney involved, if you're an executor that picks up the phone as soon as you know that you're going to be an executor of an estate, and the attorney handles most of the work, that compensation obviously won't be as substantial as if you basically handled the entire estate on your own, which we talked about can be difficult, and there are certainly traps for the unwary when it comes to administering an estate. But you can be compensated for your time as the executor of an estate. And there's a case, it's called the Johnson estate, which has a matrix of the percentages that an executor or executrix can be compensated. It's not binding, but there are courts that look at that Johnson estate case and say, okay, this amount is reasonable, and it's a breakdown on a percentage basis of what the probate estate is. So in other words, if the probate estate is worth $100,000, and I'm not, about 3% is what the executor would be entitled to. So about $3,000 in compensation for administering an estate that's worth $100,000. And then the higher the value of the estate, that percentage goes down. But it really comes back to just and reasonable compensation for the services provided. And
And at any
probate
point,
estate, I'm sorry.
okay, I'm sorry.
The probate estate, once again, to circle back what we talked about earlier, is just that. It's the probate estate. So if somebody has a life insurance policy that's worth $2 million, they have a probate estate that's worth $200,000, you don't lump in that non-probate asset and say, okay, the estate is worth $2.2 million and I'm entitled to $100,000. So
That's because
probate estate.
That's because the life insurance policy is not a tangible asset. It's not that you can really grab and hold on to, essentially.
Well, it's a non-probate asset that passes by beneficiary designation. So by its mere nature, it's really just presenting a death certificate and making the transfer. And oftentimes the executors don't even do that. It's just the beneficiary that does that. So from a compensation standpoint, you're not going to be compensated for relatively menial ministerial task if you assist with that. It has to be something that's part of the probate.
Okay. Last one question, at least for this on this sheet. Do I have any personal liability exposure for serving as the executor of an estate?
Unfortunately, you do. And that personal liability exposure can be mitigated by seeking counsel, professional counsel up front. What I see sometimes is people will try to administer an estate on their own, and they'll get the forms from the Register of Wills, and they're very well intentioned in what they're doing. But they want to try to avoid legal fees, which can be expensive at times, or all the time is something. But ultimately, they'll try to administer the estate on their own, and then something will happen, which will then cause them to seek legal counsel. Sometimes undoing that quote unquote something that happened can be more expensive from a legal standpoint, legal fee standpoint, and also from a personal liability standpoint. So I do always recommend, if you're going to be a personal representative, at least speak with competent legal counsel. And then ultimately at that point, once you realize everything that needs to be done, if you decide to go at it alone because you think you can handle it, then that's your prerogative. But at least know what you're getting into with the estate. And the way that personal liability can come about is if distributions, the main way is if distributions are made to a creditor that necessarily doesn't have priority over another creditor, or if distributions are made to beneficiaries early. And when I mean early, what I mean by early is that distributions are made to the beneficiaries before the notice of appraisement has been received from the Pennsylvania Department of Revenue. So the notice of appraisement is what you receive from the Pennsylvania Department of Revenue after the Pennsylvania inheritance tax return. Pennsylvania inheritance tax return has to be filed within 9 months of the date of death. You can receive, and this is an important point, the estate can receive a 5% discount for an early payment that is made within 3 months of the date of passing. So after the inheritance tax return is filed, it doesn't have to be filed at the 3-month period. The payment can be made without the inheritance tax return being filed. It can be an estimated payment of any amount. But ultimately, within 9 months of the date of passing, that Pennsylvania inheritance tax needs to be filed. Otherwise, interest and penalties start to accrue on the amount of tax that would be due. After that Pennsylvania inheritance tax return is filed, it takes about anywhere from 4, and now it's taking closer to 5 or 6 months to receive a notice of appraisement. That notice of appraisement will say that the return has been accepted as filed, meaning that everything that was listed on there was reviewed by the Pennsylvania Department of Revenue. They deem it accurate and it's approved. At that point, you're fine making the estate distributions to the beneficiary or paying creditors that might be due. If you make distributions prior to receiving that notice of appraisement and there are additional taxes due or there are creditors that come about and you already made these distributions, you can potentially have personal liability for making what they call at-risk distributions, not waiting until the Pennsylvania Department of Revenue has issued that notice of appraisement, not making sure that you have advertised the estate. So by advertising the estate, I mean by statute, when somebody passes and an estate is opened, the estate has to be advertised in a newspaper of general circulation in the county where the decedent lived at the time of their passing, and secondly, in the legal journal of that county as well. What that advertisement does is it puts creditors on notice that somebody has passed, and they essentially have 1 year from those advertisements being published to bring a creditor's claim against the decedent's estate. And those creditors' claims are often filed at the Register of Wills by the creditor. Doesn't mean once a creditor notifies a personal representative that they should immediately pay that creditor. I always recommend, I typically send correspondence explaining that the estate is being administered. We're evaluating what the estate assets are, and that ultimately, unless I know that the estate is going to be able to pay that creditor, and it's not going to be a close call from a solvency versus insolvency standpoint, oftentimes I'll wait until after we receive that notice of appraisement from the Pennsylvania Department of Revenue to pay off any creditors. Because if you pay off a creditor too soon and they weren't required to be paid under statute, and there was a creditor that had a higher priority, then you could be subject to potential personal liability. The other obvious way you can be subject to personal liability is you completely mismanage the estate. So, in other words, you marshal the estate assets and you start using those assets, for your personal purposes, right? So there's obviously, some potential criminal aspects of that, but also, even if it wasn't as blatant as stealing the money and it was just a mismanagement of the estate, ultimately the beneficiaries of the estate can bring all the surcharge action. They can request an accounting of the estate, a formal accounting of the estate, bring a surcharge action against the personal representative, and they could potentially be found personally liable for payment to the beneficiary.
Hmm. Wow, that's it's a little bit scary, right? Because you're trying to do the best you can, but either knowingly or unknowingly, you could do something to basically, damage what's all the work that's been put together. But again, like you said, it's the estate planning. If you have estate planning in place and you educate yourselves on these things, you can, hopefully bypass and just, keep yourself out of hot water. Um, like I said, there's just a lot of, it's a lot of uncertainty when it comes to probate items, which is why I wanted to have you on talk about this. So in your discussion, so you're done for the hot seat, so no more of those questions are done. But I heard when you were talking, you used executor, executrix, administrator. Can you explain the difference, if any, between those terms?
Sure. And the easiest way to avoid any sort of confusion is to call the person the personal representative. Within Pennsylvania, that is common to be called a personal representative, whether you are an executor, executrix, administrator, administratrix. So an executor is the male gender, executrix is the female gender of of a probate estate in which there was a will. So, they're sort of legal terms of art, in that they have a specific meaning. That if you're named an executor or an executrix, that means that there was actually a will to be probated. If the person died intestate and did not have a will, and you become personal representative of their estate, you would be called the administrator or the administratrix. So it's really just a matter of semantics. If you use the broad term or the general term personal representative, that's the umbrella that covers all four of those other names. But it ultimately comes down to whether or not there was a will or there wasn't a will, whether you're an executor or that you are a administrator.
Okay. I actually never knew that. I refer everyone as a PR personal rep. That's why. That's so.
Right, right. That's the easiest way to
Yeah,
refer to
no,
it.
yeah, because a PR, we see that PR, personal rep, and like I said, it's just very simple to say, here you go, you're the personal representative, and kind of go from there and deal with that person. Um, so, for those who again who are watching this, again, thank you very much, Kevin, from
Sure.
and
Thanks for having me.
Attorney at Law, for taking the time out. I know you're a busy guy. I know this took some time to get together. On our website, on inherithomeoptions.com, we do have some glossary, some terms there. These questions that I had asked Kevin, we're going to post them, and this video will be posted as well in its entirety on the website and stuff. So we'll have that there, and Kevin's contact information. Actually, if you don't mind, Kevin, could you, if you're okay with it, put your email address, phone number, the best way to contact you?
Sure. My email address is kconrad, KCONRAD, at Lamb Mackerlane, which is LAMBMCERLANE.com. And my phone number is 267-257-8298. And our firm is listed at www.lambmackerlane.com. We have 3 offices. Our main office is in Westchester and Chester County. We have another office in Newtown Square in Delaware County, and we also have a Center City office in Philadelphia.
What counties do you guys cover? Just those 3, or do you cover other counties?
No, we cover throughout the entire state. Quite honestly, I mean, there are matters that we handle in Harrisburg. There are matters we handle in the western part of the state. We're a full service firm, but I would say that the main counties that we cover are the 5 counties: Philadelphia, Chester County, Bucks County, Delaware County, and Montgomery.
Anyone listening to this, if they're from out of state, they physically live out of state, but the properties in here, they can, in PA, they can still contact you and deal with them. Is that accurate?
That is accurate. And also, unfortunately, that real estate will be subject to Pennsylvania inheritance taxes, even if you are an out-of-state resident.
Yep. Yeah, unfortunately. And on the flip side, if the person who's passed away is in Pennsylvania, but the property that they have a second home, and that second home's out of state, is that something you guys could potentially help out with, or is that state dependent? Or
Sure, no, we absolutely can help out with that. We deal with that quite often, whether it's in New Jersey with a shore house or in Florida. And once again, that comes into the estate planning process. Sometimes it makes sense to set up a trust in which you have a Pennsylvania situs if you're a Pennsylvania where the trust is administered. If you're a Pennsylvania resident, you have a Jersey property or a Florida property, you might want to consider putting that into a trust. So you only have one estate administration in Pennsylvania. There are, once again, it's like everything, it's give and take. There are some advantages and disadvantages to doing that. Otherwise, if you are a Pennsylvania resident, you have a New Jersey property or a Florida property, you'll have to open up what's called an ancillary estate administration in that other state. So essentially, you'll have to conduct two estate administrations.
and
When the
that's
first,
something you can assist with, you can walk them through that
sure,
process.
yes.
And last but not least, I know growing up there was, we didn't talk about this in our household. It just wasn't. And it wasn't. It was taboo. It just never came up. So someone in my mid to late 40s, um, what would you tell somebody? Like, is it ever too late to do estate planning? Is it ever, is there a good time to do it? Like, what would you tell someone who says, I'm old and forget it's too late. I'm not going to worry about it. I don't own anything. I got a few things here and there, and that's it. What would you tell someone who has that kind of attitude?
I would tell somebody first that it's not always an expensive process. So I think some people try to avoid the estate planning process because they think legal fees are going to be exorbitant. They just don't want to pay those. That's not necessarily the case with a simple estate plan. Um, Ultimately, it's going to save your loved ones a lot of potential issues if you have your estate planning in order. As far as the best time, quite honestly, it's never too soon. And I think COVID has taught us that nothing is guaranteed. And over the past year, the estate planning attorneys have been extremely busy, whether it's people having a little bit more downtime to address this issue, whether or not it's more in their face and they realize that you just never know. So they have been getting their estate planning. A lot of people have been getting their estate planning in order over this past year. Other times when people get life insurance, that's when they start to consider estate planning, whether they have and I know personally, I got life insurance when our first child was born. That's a time when you start to evaluate your own mortality, I guess. And so oftentimes people will contact estate planning attorneys while they're in that mindset of getting life insurance because it's just easier to address it all at one time.
Great. Well, taking up enough of your time. Thank you very much, Kevin. Really appreciate it. Again, Kevin Conrad from Landmaker Lane, offices in Newtown Square, Westchester, and Philadelphia. They cover a good portion of PA and some out-of-state stuff. Hit them up, talk to them, ask any questions, and as always, please feel free to visit myinheritedhomeoptions.com. We have a glossary there. Kevin's contact information and his firm's contact information will be there as well. And ask any questions you guys want. We'll feel free. And if we don't know the answer, we will definitely get it for you. Thanks, Kevin, for your time. Have a great weekend. Tell hi to the family for us, and we'll talk soon.
Thanks, David. It was a pleasure being here.
Take care. Bye-bye.